viewers, there have been claims and counterclaims about legal systems. Well, can we purport that a legal system can exist in isolation? I don't think so. Legal systems always interact with one another. This is because our human nature is social. Human beings from time immemorial have been involved or engaged in so many transactions, movements, traveling, commerce, and trading together. And this brings people closer. Once people come closer, of course, we need a legal framework that would again regulate their relationship and harmonious coexistence. This is how it is, simple. Today, I would like to look at mixed legal systems. Well, there are mixed legal systems in many parts of the world, especially in the Philippines, but I would prefer looking at South Africa. The Republic of South Africa, as we know it, has got 3 legal systems working together within one legal regime. In this case, we have the Dutch Roman civil law, we have English common law, as well as African customary law, put together and understood within the Supreme Constitution of the Republic of South Africa. The Constitution of 1993, the Constitution of 1996. Well, we see also the elevation of the African customary law to the level of English common law. That means having the same status. It would also be applicable in the areas that are of concern to the members that are subjected to it, and as well as the judicial practice of judge-made law or the law of precedence or case law. But on the other hand, we see such principles as Ubuntu principle being entrenched in the South African law. And in that case, we find huge contribution of the African customary law in the book of law, that is the Constitution of the Republic of South Africa. The Constitution of 1996 under Chapter 12 recognizes traditional leaders and also African customary law. This enables the development of the African law jurisprudence or African customary law jurisprudence, as well as many other cases that have got certain terms and principles that are ambiguous, especially in the Bill of Rights. What is the right to life? This is the interpretation of the right to life, the interpretation of cruel, inhuman, and degrading punishment when it comes to the controversial practice of death penalty in South Africa. Well, this is again the question of understanding the humanity and the African contribution in the jurisprudence and the understanding of the practice of death penalty. There are so many these debates that need our attention, but most importantly, such kind of putting together different legal systems into one legal system would enrich one another. As I said, people interact, but even the laws, legal systems interact. Law scholars, we interact through our thinking and the way we interpret certain legal concepts and how we apply the rule of law, how we apply human rights, how we apply constitutionalism, and how we apply such concepts as democracy. South Africa is presenting us a best case scenario when it comes to the integration of foreign legal systems within the domestic, what I would call indigenous legal system, and that is the African customary law, not vice versa. And in that case, we are compelled to look at the African customary law not as neglected legal system, not as a legal system that has always been frustrated or oppressed by other legal systems, but a legal system that has been resilient and is seeking to find its identity in the modern understanding of the jurisprudence. Thank you for watching. Peter here, University of Nairobi School of Law, Kisumu campus. I expect to see you again. Bye bye for now. Thank you.